then in what's at play in as far as that court process involving that teenager in Limpopo is concerned. We're joined by attorney and child law specialist from the Center for Child Law Lithalethemba Stwayi, joining me now for that conversation. Lithalethemba, thank you so much. I really appreciate this opportunity and you sharing your insights with me. Let's start with, the lawyer for the teen is expected to apply for bail and ask that the child, the teenager, be released into her parents' care. As far as your understanding is concerned, this is in line with what is supposed to happen in instances where a child is in trouble with the law. In other words, it's a different way of dealing with the matter as opposed to the standard way of saying bail, is it in the interests of justice or not? Will the accused return to stand trial or not? But there are other considerations where a child is concerned.
Yes, so the child justice system under the Child Justice Act actually states that arrest and detention is a matter of last resort for children. So depending on the nature of the crime, whether it's very serious or not as serious, that is part of the factors that are considered. So with this matter, usually a child is already released once they're arrested. They're already released into the care of the parents if you can ascertain that she will remain there, and you will be able to make sure that she goes to court on the date that she's supposed to appear. But it could also be because of the fact that it's such a small community that it was part and parcel of kind of trying to figure out what's in her best interest. Firstly, also regarding to her safety, that she may have been placed in a child and youth care center. But because as you've stated, that she is not coping, then they are going back to court to try and have her placed within the care of the family.
How important is it, Lithalethemba, to separate matters here? On the one hand, we're dealing with the tragedy of a child who died by suicide, and that really hit the whole country. But when it comes to the actual formalistic court processes before the court in Thohoyandou, we're not dealing with a child who's charged with murder. We're dealing with a child who's charged with assault with intent to do grievous bodily harm, but a child nonetheless.
Yes, so that's exactly it. We're not dealing with a child who committed murder. We're dealing with a child who committed assault, and she's been charged with assault, which is a Schedule 2 offense. And basically with that, the probation officer does the investigation, speaks to the child, speaks to the parents, gets and ascertains the circumstances of the child, ascertains her age, and also gets the facts of the actual offense that was committed and whether she wants to actually take accountability. And that comes into the report that she then gives to the presiding officer during the preliminary inquiry at court.
And Lithalethemba, do issues of capacity of the child come into play here? Because as far as I know, the criminal capacity of a child starts at the age of 12 as of what, since the Child Justice Amendment Act. Has it come into operation as an act?
Yes, it has. The amendment has come into operation. So age does play a pivotal role. Yes, children can commit crimes, but depending on their age and capacity to actually know that the difference between right and wrong. So with younger kids, it's more difficult to get that criminal intent. So children under 12, that's why children under 12 do not have the criminal intent. But between the age of 12 and 14, the presiding officer has a big task to actually ascertain also whether this specific child understands the difference between right and wrong with what she has done and is willing to take accountability. Over the age of 14, then the criminal intent is there.
What is your understanding of what the object of justice and dealing with the acts of a child that are criminal in nature? What are those objects? In other words, our criminal justice system, sometimes sets objectives that have to do with rehabilitation and reintegration to basically teach you that, this behavior, we frown on it as a society, don't do it again, and sort of build character in you. What's your understanding of how to strike that balance that says justice for a crime, for instance, of assault, GBH, justice is served, but this child, whose best interests continue to be paramount in terms of our Constitution, even as she's in trouble with the law. What's that balance like? How does it land as a balance between the two?
So the Child Justice Act works on restorative justice, which is a few of the things you've mentioned: taking accountability, making restitution, and having reconciliation and reintegration back into society. And there's a reason why the Child Justice Act was enacted, because children are still more malleable than adults. Hence, they're treated differently, children under the Child Justice Act and adults under the Criminal Procedure Act. So while the child has committed an offense, she is going through the criminal justice system. It's not a great system. Going to court, being around the police, being retained at this point. So part of it is she has to face the consequences of her actions, and that is part and parcel of why we have the probation officer, who is the social worker who is involved in the case, to explain everything to the child, explain the processes and what to expect, but also while she is still going through the actual formal criminal justice system. It will then come into play as to how the child, whether she acknowledges her wrongdoing and actually tries to make amends. Unfortunately, in this case, the victim of the crime is no longer with us, but we still have a child central to this case where she still needs to move forward, depending on what the conviction is and what punishment, if I can put it that way, that she gets. It's still a big part of her life. She still needs to kind of go through life having taken cognizance of the fact that her action in assaulting Lufuno led to the consequence of Lufuno no longer being with us. But her crime is assault. So the formal justice system will move according to that, that we are dealing with a crime of assault, whether she is sentenced to community service or she has to go through diversion, which is diversion outside of the criminal justice system, while attending classes or held in a child and youth care center. So it'll all depend on the facts of the case and how it pans out.
Just lastly, and I suppose this is not a strictly legal question, but I suppose at one level it is, it does have legal aspects to it in terms of dealing with the community's sense of what's right and wrong. What would you say in weighing in on a community that's shocked by this child dying by suicide, Lufuno, at the same time abhors issues of bullying in schools, which rear their ugly head from time to time, not only in that part of the country but across the country in general, but at the same time dealing with a child who's more than likely now in deep trouble herself, including being in trouble in terms of coping mentally with the consequences of what transpired at school. What are some of the, what would be your contribution? Because you, as Center for Child Law, deal with children in trouble with the law quite a lot and have been instrumental in the development of, child law in this country.
So I think the biggest thing that's hit South Africa and the community is the death of Lufuno and coping with that and what led her to actually take her life. And then we, conjunctively with that, we have the child who committed assault. So I'm not going to say it's misplaced. Everyone has a right to how they feel and how they internalize things that occur. So at this particular time, the Child Justice Act is in place to make sure that the human dignity, the best interest of the offender as well, are taken into account while she's going through the criminal justice system. It's very unfortunate. I actually think it's a bigger conversation than where we are now. It speaks to violence. And even the reasons as to why the alleged offender chose violence in that moment and the interventions. What was the school itself? It seems that a lot of people failed that community and that school in this particular case, from the actions of the school to lack of interventions, maybe if there were interventions by social workers with regard to the offender before she actually got to that point, something may have happened. And even with Lufuno, when it finally came to light, if there were any interventions, if she was taken to counseling, if the school took an initiative, if DSD took an initiative to actually send social workers. So there's a lot that we need to grapple with. There's a lot we still need to do with violence in this country. Sure. But I do think that as hard and as difficult as this case is, there's still a child at the center of it. There's still a child who made a mistake, an unfortunate one, who is now going through the criminal justice system, rightly so, because she did commit assault, but who needs to then also move forward. The community is probably angry, but at the end of the day, even the penal system in South Africa is about restorative justice, not just the Child Justice Act, but also the Criminal Procedure Act. A person does their time and you hope that they are rehabilitated at the end of the day so that they can be an upstanding member of society.
Lithalethemba Stwayi, thank you so much for your insights here on All Angles.